Imagine stepping into your favorite bakery on a sunny morning. The smell of fresh pies fills the air. You decide to buy an apple pie. You pay the cashier and they hand you a warm, delicious pie. This is a simple transaction. You exchange money for a tangible good. This everyday scenario forms a fundamental part of our understanding of property rights. Property rights are about ownership. When you buy a pie, you expect to own it. You expect the pie to be yours to eat or share. Understanding this simple exchange helps unravel more complex situations. One such situation is the stock market, where property rights take on a different meaning. Here, the rules of ownership and transfer are not always straightforward. To fully grasp the intricacies of property rights, we need to look beyond the bakery. We need to explore how these rights apply in more complex transactions. This journey will take us from buying pies to buying cars, and eventually to trading stocks. It will help us understand how consumer expectations and business obligations differ in each case. When you buy a pie, the transaction is clear and immediate. You pay the price, and you receive the pie. The pie is a physical good. You can see it, touch it, and taste it. This tangibility makes the concept of ownership straightforward. The baker's obligations are simple too. They must provide the pie as promised. Consumer expectations in this scenario are clear. You expect the pie to be fresh, delicious, and worth the money you paid. If the pie is moldy or burnt, you have a right to complain. You might ask for a refund or a replacement. This expectation is reasonable and aligns with common business practices. The simplicity of this transaction underpins our basic understanding of property rights. The pie is a tangible object. Ownership is transferred immediately upon payment. Both parties understand their roles and obligations. This clarity is essential in everyday transactions and forms the foundation of more complex property rights scenarios. Let's move to a slightly more complex scenario: buying a car. Unlike a pie, a car is a significant investment. The transaction involves more steps and considerations. You research different models, check prices, and perhaps negotiate with the dealer. Despite the complexity, the core principle of property rights remains the same. When you buy a car, you expect to take ownership of it. This ownership means you can use the car as you wish. You can drive it, lend it to a friend, or sell it later. The dealer's obligations are more extensive than the baker's. They must ensure the car is in good condition, matches the description, and has all necessary documentation. Consumer expectations in car purchases are higher due to the investment's size. You expect the car to be reliable and worth the price. If any issues arise, like undisclosed damages, you have a right to seek redress. This scenario shows how property rights and consumer expectations scale with the complexity and value of the transaction. Buying a car introduces legal and contractual elements. You might sign a sales agreement which outlines the terms of the sale. This document protects both the buyer and the seller. It specifies the car's condition, any warranties, and the payment terms. Such agreements are crucial for more valuable and complex transactions. Ownership transfer in car purchases involves more than just handing over keys. It often includes registering the car in your name, which might require government paperwork. This process ensures that the property rights are legally recognized and protected. The dealer must comply with these legal requirements to complete the sale. Consumer protection laws also play a role. These laws ensure that buyers are not misled about the car's condition or value. They provide recourse if the car turns out to be a lemon. This legal framework helps maintain fairness and transparency in more complex transactions. It shows how property rights extend beyond simple exchanges to encompass legal and regulatory elements. Section 5. Understanding intangible assets, stocks. Now let's shift from tangible goods to intangible assets like stocks. Stocks represent ownership in a company. When you buy a stock, you don't receive a physical item. Instead, you gain a stake in the company's future profits. This type of ownership is less tangible but equally important. The stock market operates differently from a bakery or a car dealership. Transactions happen electronically, often through brokers. Ownership transfer is not immediate. It involves updating records in the company's books. Despite this, the fundamental principle of property rights remains. You own a portion of the company when you buy its stock. Consumer expectations in stock trading are complex. You expect to benefit from the company's success. This could be through dividends or an increase in stock value. However, unlike a pie or a car, the value of your stock can fluctuate. And in unique cases, your securities can become tradable even against the wishes of the issuer. This introduces a level of risk that isn't present in simpler transactions. Understanding these nuances is crucial for anyone participating in the stock market. Section 6. The concept of short selling. Short selling adds another layer of complexity to stock transactions. In short selling, you borrow stocks and sell them, hoping to buy them back later at a lower price. It's essentially betting that the stock's price will drop. If the price falls, you profit from the difference. If it rises, you face losses. This type of transaction blurs the lines of ownership. When you short sell, you don't actually own the stock you're selling, you're borrowing it. This creates a unique dynamic in property rights. The original owner retains ownership, but the short seller temporarily controls the stock. The obligations and expectations in short selling are different from regular stock trading. The short seller must return the borrowed stock at some point. This involves paying interest or fees to the lender. For consumers, understanding these obligations is crucial. It helps them navigate the risks and complexities of short selling effectively. In stock trading, the roles and obligations of parties are clearly defined. Brokers ideally facilitate transactions, ensuring they comply with market regulations. Companies must disclose financial information to keep investors informed. These disclosures help investors make informed decisions, aligning with the principle of transparency. Investor expectations include fair and transparent trading practices. They expect their brokers and the regulators to act in their best interests. If a broker and/or regulator engages in unethical behavior, it can significantly impact the investor's financial well-being. Regulatory bodies exist to enforce these standards, ideally protecting investors from fraud and manipulation. However, the intangible nature of stocks introduces risks not present in simpler transactions. Market volatility can affect stock prices dramatically. Investors must be aware of these risks and manage their portfolios accordingly. Understanding the obligations and expectations in stock trading is crucial for navigating these complexities and protecting one's investments. A real-world example of regulatory failure is the 2008 financial crisis. This crisis highlighted significant gaps in the regulation of financial markets. The crisis was partly caused by excessive risk-taking and lack of transparency in financial products like mortgage-backed securities. These products were complex and not well understood by many investors. Regulatory bodies failed to enforce adequate oversight. This allowed financial institutions to engage in risky behavior without sufficient checks. When the housing market collapsed, the value of these securities plummeted. Investors faced massive losses, leading to a global financial meltdown. This failure underscored the importance of stringent and effective regulation. The crisis had far-reaching impacts. It led to massive job losses, foreclosures, and a severe economic downturn. Many investors lost their life savings. The lack of transparency and oversight eroded trust in financial markets. This example shows how regulatory failures can have devastating consequences, affecting both individual investors and the broader economy. Effective regulation plays a crucial role in maintaining market fairness and transparency. Regulations are supposed to ensure that all parties adhere to ethical standards. They're meant to protect investors from fraud and manipulation. Regulatory bodies like the Securities and Exchange Commission, SEC, are in place to enforce these rules, supposedly to create a level playing field. For consumers, understanding these regulations is vital. It helps them know their rights and the protections in place. Regulations require companies to disclose financial information, ensuring transparency. This allows investors to make informed decisions based on accurate information. It also holds companies accountable for their actions. However, the rules and regulations must apply to all parties in a position to affect investors. FINRA shouldn't be allowed to arbitrarily change the rules whenever they choose, and there should be negative consequences if they decide to do so. The SEC should be there to investigate instances where FINRA is suspected of not following their own rules. And if it becomes obvious that they aren't capable of effective oversight, we have to devise a system that actually seeks to prioritize the protection of investors. Effective regulation should protect consumers without hampering market dynamics. This balance ensures that property rights are respected and that markets operate smoothly and fairly. Understanding property rights is essential in both simple and complex transactions. From buying a pie or a car to buying and selling stocks, these rights define ownership and expectations. They ensure that consumers receive what they pay for and that companies fulfill their obligations. In the stock market, these principles become more intricate. Transactions involve intangible assets and complex mechanisms like short selling and derivatives. Regulatory frameworks are crucial in maintaining fairness and transparency. The 2008 financial crisis highlighted the devastating effects of regulatory failures, but some of the issues from 2008 are still a plague on today's market. The rules and regulations in place are intended to protect investors and ensure market stability, but too often we see that the rules aren't effectively enforced. Investors have very little trust in today's financial markets. Observe the fact that FINRA is an industry-funded organization, and you begin to understand that FINRA owes their existence to the very members they're in charge of policing. The line between FINRA and member firm is blurred when you see that the CEO of GTS Securities, the firm linked to the earliest and final trades in MMTLP, has been a part of FINRA's Market Surveillance Advisory Group for multiple years, and has been hands-on in discovering market manipulation on behalf of other high-frequency trading firms. FINRA acted outside of their scope of duty when they modified and later revised the MMTLP Corporate Actions before posting them to their daily list. In doing so, FINRA created a settlement issue that would have been caught if FINRA had any true intention of adhering to their Rule 6490 review process. FINRA took the time to revise the MMTLP Corporate Action on December 8th, but the revision still resulted in a U3 halt. Rather than adjusting the dates in yet another revision, FINRA allowed the halt to persist long enough so that the brokerages that had plans to force liquidate short positions couldn't do so, and to delete the MMTLP symbol presumably so that settlement of short positions could never take place. If we were to look at this situation in terms of pie, just think of a very famous bakery deciding to close, but they clearly indicated that you'd have 2 final days to pick up the pies that you paid for. In a surprising twist, the FDA closes the bakery 2 days early and demands all food items to be destroyed. You later learned that members of the FDA were selling these pies without actually having them in their possession. Rather than running the risk of having to pay a higher price to locate pies on the last 2 days, the FDA shutting down the bakery saves the pie short sellers at the expense of those that owned their pies and could have sold them at a higher price if they chose to do so. It's called supply and demand. It's a fundamental concept that drives the entire U.S. stock market as well as provides for accurate pricing of securities. The whole idea of a squeezes where prices shoot up astronomically are only made possible by unchecked counterfeiting. In terms of property rights, the regulatory failures concerning MMTLP become apparent when you recognize that it is currently impossible for all prior holders of MMTLP to have received real shares of NextBridge hydrocarbons, and therefore it is impossible that every holder can receive the same entitlements afforded to actual shareholders. You don't even have to take my word for it. Just look at how FINRA explains the situation in their own words. Also notice how their story evolves in the 8 months between their 2 FAQs. The number 10 question in FINRA's March 16, 2023 FAQ is as follows. What should investors do if they believe they have not received their NextBridge shares? The first sentence of the answer says, if you held a settled position in MMTLP on December 12, 2022, your account should reflect your position in NextBridge. We can all agree that it should reflect your position in NextBridge, but this is different from saying that every holder did in fact receive their shares of NextBridge. The following sentence says, your broker-dealer is required to maintain possession or control of your shares in compliance with federal law. This tells me that even if a corporate action doesn't instruct brokerages to close short positions, it's probably in their best interest to prioritize doing so in order to be in compliance with federal law. Fast forward 8 months after FINRA's first FAQ, 11 months after the U3 halt of MMTLP, and FINRA's story is slightly different. Question 12 in the FAQ reads, were the right number of NextBridge shares distributed in connection with the corporate action? This isn't the question that people were asking. The fact that MetaMaterials distributed the 165,472,241 shares on a one-for-one basis doesn't tell anyone if the brokerages were allocated enough NextBridge shares to facilitate a one-for-one exchange for every share of MMTLP held by their clients. FINRA proves this to be the case in their response to question 14 when they say, based on FINRA's subsequent regulatory efforts, FINRA estimates that there was an aggregate short interest position in MMTLP in accounts held at broker-dealers as of December 12th of approximately 2.65 million shares out of 165.47 million total shares outstanding. It's important to note that FINRA characterizes this figure as an estimate. However, this estimate is considerably lower than the number NextBridge Hydrocarbons claims to have been solicited for. This discrepancy is noteworthy. But let's just stick with the approximate 2.65 million in short interest. This plan is currently on hold, but NextBridge once intended to offer interest in another company to all NextBridge shareholders that transferred their shares to the transfer agent. In a scenario where all of the original 165,472,241 shares of NextBridge were somehow transferred to the transfer agent, every NextBridge shareholder would be entitled to interest in the other company, but it would be impossible for the holders of approximately 2.65 million shares to receive the property in which they were entitled. With this in mind, ask yourself, how is it that not even the United States government can deprive someone of their property without due process, but somehow we're supposed to believe that it's acceptable for FINRA to do so? FINRA has absolute immunity, but this only applies when they're acting within the scope of their authority. One possible reason that the SEC is yet to point out that FINRA had no authority to modify or revise the MMTLP corporate actions is that it would leave them open to litigation. This is the procedure that FINRA should have followed. FINRA was only supposed to review the submission made by MetaMaterials. If FINRA discovered any issues, they were supposed to deem the submission deficient and provide the issuer with a written notice explaining the reason for the determination, along with instructions on how to appeal. Instead, FINRA hijacked the MMTLP corporate action and made changes that contradicted the previous disclosures that were made public by NextBridge Hydrocarbons and MetaMaterials. When FINRA revised or amended the corporate action on December 8th, they were essentially declaring the initial corporate action deficient. But how could FINRA provide a written notice to MetaMaterials explaining that the corporate action had the wrong share cancellation and effective dates when it was FINRA that changed the dates? So, according to FINRA, they amended the corporate action to reflect that it was FINRA that would be deleting the MMTLP symbol on December 13th because it was FINRA's role to delete trading symbols, not to cancel shares. Close observation of the revised MMTLP corporate action that resulted in a U3 halt reveals that there's no mention of the roles that were to be carried out by MetaMaterials and NextBridge Hydrocarbons. There's no mention of share cancellation, distribution, and even the term record date was removed. The main focus of the corporate action was the deletion of the MMTLP symbol on December 13th, a date and action that doesn't appear in any of the previous disclosures from the issuers. Then, on December 9th, before the trading day could begin, FINRA U3 halted trading due to an extraordinary event. What was the extraordinary event? According to FINRA, they halted trading to protect investors that might have purchased MMTLP after December 8th, unaware that they wouldn't be entitled to the NextBridge distribution. So why did both MMTLP corporate actions include a line that read, "Purchases of MMTLP executed after December 8th, 2022 will not receive the distribution"? Basically, FINRA informed all market participants of this detail, but they also, U3, halted trading because they apparently didn't believe that they would be understood. This so-called extraordinary event was due to an issue related to settlement and clearance, and it was based on information known by FINRA long before December 9th. It's impossible that FINRA properly reviewed the corporate action in accordance with Rule 6490 because ensuring that there are no issues related to settlement and clearance is a part of the necessary criteria before a corporate action can be posted to FINRA's daily list. By FINRA making changes and analyzing the MMTLP corporate action to the point that they realized they needed to U3 halt trading, they were essentially conducting their Rule 6490 review process in the wrong order. The purpose of reviewing a corporate action is to ensure that when the information is made public, all market participants are given ample opportunity to react to the pertinent information. What was that pertinent information? According to the December 23rd Metamaterials PR that was referenced by FINRA in their March 16th FAQ, each holder of MMTLP, as of 4 p.m. Eastern Time on December 12, 2022, would be entitled to receive one share of NextBridge common stock, which was to be distributed on December 14, 2022 at the close of the trading markets. It was at this time that all shares of MMTLP would be automatically canceled and would no longer be tradable on the OTC market. December 14th was such a crucial date. This is what should have happened if the MMTLP corporate actions were consistent with the information made publicly available by NextBridge Hydrocarbons and Metamaterials. For every share of MMTLP held, there should have been a 1-for-1 exchange for a new share of NextBridge Hydrocarbons. In this image, you can see an exchange-type corporate action from FINRA's daily list that accurately depicts the way the MMTLP corporate actions should have been written. Observe how the effective date of the exchange described in the body of the corporate action matches the effective date at the top of the corporate action. Also, take note of the fact that there weren't over 50,000 letters sent to representatives in the name of OBSVF. Could it be because FINRA carried out the corporate action the correct way? Now, let's look at the initial MMTLP corporate action once again and see if we can identify the problem created by FINRA. Notice that it says MMTLP shareholders will receive one share of NextBridge Hydrocarbons for every one share of MMTLP held on the pay date of December 14, 2022. It later goes on to say that the MMTLP shares will be canceled effective December 13, 2022. How could anyone be holding MMTLP on December 14th to take part in the exchange if the shares get canceled on December 13th? This had to be at least one aspect of the corporate action that the DTCC wanted to discuss. As written, this corporate action couldn't be carried out because the canceling of MMTLP on December 13th would have meant that there'd be no holders on December 14th qualified to take part in the 1-for-1 exchange for NextBridge. Also, in a position close only scenario, if a MMTLP holder sold their shares as late as December 12th to a short position holder buying to close, then by December 14th, that trade would have been settled, and the seller wouldn't have been entitled to receive NextBridge shares. Absolutely no one looked at the initial MMTLP corporate action and thought to themselves, gee, I wish I had clarity on when FINRA planned to delete the MMTLP symbol, and yet that's what FINRA claims as one of their priorities when they revised the MMTLP corporate action on December 8, 2022. FINRA wrote in their FAQ, on December 8th, FINRA amended its original December 6th corporate action announcement to clarify, among other things, that it would be deleting the MMTLP symbol on December 13th rather than canceling the shares, because the issuer itself was responsible for canceling the Series A preferred shares. Here, FINRA pretended that the problem wasn't that they included an incorrect December 13th share cancellation date, a date that would have prevented the possibility of MMTLP being automatically canceled again upon the distribution of NextBridge on December 14th, after market close. But instead, they make it seem that the real issue was that they weren't clear about FINRA's role. When you look at the changes made by FINRA in their December 8th revised corporate action, you'll see that they did the exact opposite of adding clarity. FINRA removed the record date terminology. They removed the reference to December 14th being the pay/distribution date, and they no longer include a share cancellation date. All of these changes are the exact opposite of clarity. Since FINRA removed the record date terminology, the reader of this corporate action can now only assume that December 12th was the record date. The first line of the revised corporate action reads as follows: MMTLP shareholders with settled positions as of December 12, 2022, will receive one share of NextBridge Hydrocarbons Inc. for every one share of MMTLP held. Did you notice the difference? It no longer says that the shares of MMTLP have to be held on the pay/distribution date of December 14th. It merely says held. Again, this is the exact opposite of adding clarity. Before addressing the final change, I'd like to point out that FINRA points to the initial corporate action in beginning with the wording "See Daily List of December 6, 2022. This is confusing because it gives the impression that you needed to see both corporate actions to know what was going on. This is evident by the fact that the initial corporate action contained pertinent information that wasn't included in the revised corporate action. The only thing aside from a lack of clarity that the revised corporate action included exclusively was that the MMTLP symbol would be deleted on December 13th. This detail was not needed. It wasn't an aspect of the process mentioned by Metamaterials or NextBridge, and it isn't something, as far as I can tell, that FINRA has ever included in any other exchange-type corporate actions. This is important because it's only the information within the corporate actions and the guidance from FINRA that can dictate the way brokerages and investors are to respond. 3 months after the U3 halt of MMTLP, FINRA finally added clarity concerning the MMTLP share cancellation date in their March 16th FAQ, when they pointed out several times that the shares were indeed canceled on December 14th, the distribution date. FINRA never owns up to the fact that it was a mistake to include a December 13th share cancellation date on the first corporate action. By not including the correct December 14th date on the revised corporate action, FINRA continued to mislead their member firms and the investing public, especially since the effective date of the corporate action was still linked to the incorrect December 13th date. This is seemingly FINRA's reason for including symbol deletion, because since it was a role carried out by FINRA and not a date mentioned by the issuers, FINRA was able to say that December 13th was the day that the MMTLP symbol was to be deleted, even though it's more common practice to delete the symbol in conjunction with share cancellation, or even afterwards. There's no way to imagine that this wasn't an intentional act of deception. FINRA was given a second chance to get the corporate action right. They knew that they included the wrong share cancellation date on the first one, but somehow they neglected to include the correct December 14th date on the revision. It's important to remember that brokerages deal with thousands of tickers. If FINRA is posting incorrect information on their daily list, the brokerages aren't going to go out of their way to fact-check or second-guess FINRA. Evidence of this is clearly seen in the communication between brokerages and their clients that held MMTLP. Here's a screenshot from Trading 212 declaring that the MMTLP share cancellation date was December 13th. And here's an image that includes a nearly identical message from TD Ameritrade and Charles Schwab that was sent to clients as late as December 9th, 2022, the day of the U3 halt. These messages make it clear that FINRA misled brokerages, which resulted in brokerages misleading their clients. This is another example, this time from Webel from December 13th, 2022. According to this message to a client, Webel was under the impression that the pay date for the one-for-one NextBridge hydrocarbon spinoff was December 13th, which also aligns with the delisting of MMTLP. All three of these examples are proof that these brokerages relied on information from both MMTLP Corporate Actions because the December 13th share cancellation date only appeared on the first corporate action. FINRA didn't bother including the correct December 14th date on the revision. Either this, or they only relied upon the initial corporate action. Again, let's take a look at the December 8th revised MMTLP corporate action. We're going to try to make sense of it, and we're going to take a look at the plans and the actions taken by the brokerages. This message from TD Ameritrade was shared multiple times, addressed to several names, and a nearly identical message came from Charles Schwab, which completed their purchase of TD Ameritrade. Notice that near the top of the message dated December 9th, 2022, it reads, "Scheduled pay date for this distribution is December 14th, 2022. This is in reference to the initial MMTLP corporate action from December 6th. But why would they be referencing the prior corporate action if the revised corporate action provided clarity? The next passage in the message reads, "New long purchases, buys of MMTLP executed after December 8th, 2022 will not receive NextBridge Hydrocarbons Inc. shares. As such, after market close on December 8th, 2022, new long buy orders of MMTLP placed after market close on December 8th, 2022 will be routed for review and canceled." This portion of the message sounds like TD Ameritrade and Charles Schwab's interpretation of this line that was included in both MMTLP corporate actions. Purchases of MMTLP executed after December 8th, 2022 will not receive the distribution. This shows that based on the information from both MMTLP corporate actions, two very large brokerages that have very experienced employees with what I'd imagine is multiple years of experience in understanding the language of corporate actions. They understood not to allow new purchases of MMTLP after December 8, 2022. This nullifies FINRA's argument that they had to U3 halt trading in order to protect the investors that might have bought MMTLP after December 8th. It wouldn't have been a possibility at TD Ameritrade or Charles Schwab, to say the least. In the next portion of the message, they describe a position close-only trading scenario when they say, new closing sell orders of MMTLP should be routed normally, but there may be liquidity issues on December 9th, 2022 and December 12th, 2022. Current open long buy orders that are good till canceled will be canceled after market close on December 8th, 2022. This is saying that the only transactions that could have occurred on December 9th or December 12th would have been long position holders of MMTLP seeking to sell their shares to MMTLP short position holders. These transactions would have canceled each other out because the seller would no longer be entitled to receive shares of NextBridge, and the short position holder would be merely removing their liability to deliver MMTLP. In accordance with the wording of both MMTLP Corporate Actions, TD Ameritrade and Charles Schwab were planning to give their clients an opportunity to close out their positions, and at the same time, they had measures in place to prevent any new purchases after December 8, 2022. The last part of the message, in addition, MMTLP shares will be canceled December 13, 2022, and no trading will occur. Again, this shows that the brokerages had to either rely on both MMTLP corporate actions or they were only referencing the first. This is because FINRA didn't provide enough information in the revision. Every decision made by every investor and brokerage concerning MMTLP since FINRA posted the first corporate action on December 6, 2022, has been a decision based on misinformation and deception. Right here in this image, you can clearly see that the volume increased significantly on December 6, 2022, likely due to the corporate action being posted to the daily list. For anyone that was on the fence and for anyone that doubted this was really going to happen, it was the corporate action being posted that likely took away those concerns, even though somehow FINRA managed to include an incorrect share cancellation and effective date. This, of course, led to the December 8th revision. What's interesting here is that the volume was nearly triple of what it was on December 6th, but the price mainly went down. We know that TD Ameritrade and Charles Schwab's plans were to continue position close only trading on December 9th and 12th. Jeff Mendel, the then VP of OTC Markets, appeared on Trader TV Live on December 7th and repeatedly pointed out that December 12th would be the last MMTLP trading day and to expect volatility. Thousands of investors have put their lives on hold to some degree for the past 18 months because they believed their brokers and the VP of the market where their security traded, when they were told that they'd have 2 additional trading days to make a decision. So how are we supposed to believe that all of this volume on December 8th can be attributed to people just deciding to sell all of a sudden? The more logical explanation is that the majority of this volume can be attributed to short-selling activity. In addition, the price already dipped significantly during the pre-market hours of December 8th, when there shouldn't have been any trading activity in OTC securities. Are we supposed to believe that FINRA suspected fraud/manipulation in MMTLP as late as December 5th, enough to begin a blue sheet investigation and attempt to compare findings with the SEC? But there was nobody from either agency that noticed the illegal pre-market activity on December 8th? I'm 99.9% sure that this is what really happened. When clients contacted TD Ameritrade and Charles Schwab, and when they sent messages to their clients as late as December 9th, the brokerages were only referencing the December 6th MMTLP corporate action in their responses. This is clear because the messages refer to the December 14th pay/distribution date and the shares being canceled December 13th, but they never refer to symbol deletion. Then on December 13th, it appears that every brokerage that held MMTLP underwent some form of mandatory exchange or reorganization that removed the name MMTLP and replaced it with a contra QSIP or identifier. This appears to fall in line with the December 13th deletion of the MMTLP symbol from the revised corporate action. Do you recognize the problem? Based on these messages from TD Ameritrade and Charles Schwab, They only provided guidance based on the initial corporate action. FINRA revised the MMTLP Corporate Action on December 8th without following the proper procedure outlined in their own Rule 6490. And by procedure, I mean that a proper review of the corporate action would have resulted in a deficiency determination. If the problem was the fault of metamaterials, then they would have been issued a notice explaining the problem, and they would have been given 7 calendar days to appeal. FINRA clearly didn't follow this procedure, and therefore they didn't provide enough time for the brokerages or any other market participants to adjust to the new information in the December 8th corporate action. Evidence of this comes from a December 15th message from TD Ameritrade. Because I couldn't find a high-quality version of this December 15th message, I also included a clearer version of the text from another later message that makes it easier to see the text. What you're seeing is that December 15th is the earliest example of TD Ameritrade referencing the December 8th revised MMTLP corporate action. The line, according to a FINRA notice, MMTLP shareholders who had settled positions as of December 12, 2022 will receive 1 share of NextBridge Hydrocarbons Inc. for every 1 share of MMTLP held. You can see in this image that includes the text from both MMTLP corporate actions that it's clear TD Ameritrade is now referencing the revised corporate action. In their prior messages from as late as December 9th, TD Ameritrade referenced information that could only be found in the initial December 6th corporate action, including that the aforementioned line once continued after the word held to include on pay date of December 14th, 2022. OTC markets recognize this issue as well because after more than a year of trading, the OTC didn't give MMTLP the caveat emptor, buyer beware, designation until December 8th, sometime after FINRA posted their revised MMTLP corporate action to their daily list. The OTC made it abundantly clear why they had to do so. Just read the notice. OTC Markets Group Inc., OTC Markets, has designated Metamaterials Inc. Series A preferred stock, MMTLP, with caveat emptor due to public interest concern and potential confusion amongst market participants regarding dates and entitlements for the share exchange published by FINRA on December 6, 2022, and subsequently revised on December 8, 2022. There it is in plain English. Months later, FINRA would claim that the revision was to add clarity, but at the time that the actual corporate actions were released, almost everyone else noticed that the corporate actions weren't quite right. You can also observe from this Charles Schwab source, the reason given by OTC markets to give MMTLP the caveat emptor designation does fit the criteria, specifically the portion about disruptive corporate actions being a public interest concern. In the case of MMTLP, FINRA never included the correct share cancellation or effective date. Brokerages and investors were in the dark and left unsupported as to how to proceed. FINRA acted outside of their scope of duty, and as a result, they unfairly deprived investors of their property in the form of a one-for-one exchange and any potential future entitlements presented to holders of NextBridge. The MMTLP community encourages Congress to set a date for a hearing concerning MMTLP. It's been over 18 months, and the evidence continues to suggest that the regulators weren't focused on protecting investors.